Gary DeWall here, and this is Bridging the Week for September 8th to 12th, and today is September 15th, 2014. Good morning! Bad facts make bad law. We all know that. As a result, many lawyers are eagerly awaiting the outcome of a federal lawsuit by the Commodity Futures Trading Commission against a lawyer for aiding and abetting his client's unlawful acts. The CFTC also took the spotlight this week when its new chairman testified before the Senate Banking Committee, providing some initial views on what he thinks should be the agency's priorities, as well as when its enforcement division brought and settled an administrative action against an introducing broker for not following its own AML procedures. We have lots of important stories this week to cover, so let's get going. Jay Grossman, a Florida-based attorney, was sued by the Commodity Futures Trading Commission last week in a federal court in Florida for allegedly aiding and abetting violations of law by his clients in connection with their precious metal transactions for retail persons. Although the CFTC alleged that Mr. Grossman engaged in wrongful conduct since at least 2009, the agency only charged him with violations for between July 16, 2011 and February 25, 2013. This was because on July 16, 2013, the Dodd-Frank Act became effective, making the relevant transactions subject to the CFTC's enforcement authority. Specifically, the CFTC alleged that during the relevant time, Mr. Grossman helped four of his clients, who allegedly held themselves out to the public as metals clearing firms, to engage in unlawful off-exchange retail commodity transactions and fraud. These firms included Hunter Wise Commodities and related entities. The CFTC also charged Mr. Grossman with assisting in similar violations of law by other firms that also were his clients. Each of the firms assisted by Mr. Grossman had been subject to orders by federal courts finding that their precious metal transactions violated applicable law. In general, firms selling physical metal on leverage to retail clients and providing ancillary services, such as financing, must comply with strict requirements regarding handling the physical metal and customer funds. Instead, the reference firms in this action typically held customer funds improperly and never owned or processed physical metal as required. According to the CFTC's complaint in this matter, Mr. Grossman's, quote, role went well beyond the provision of legal advice, end of quote, in connection with assistance to Hunter Wise and the other companies. In his complaint, the CFTC quotes from statements made by Mr. Grossman, captured in conversations tape recorded by a principal of one of Mr. Grossman's clients to help support his charges. According to a statement issued by Aiton Goldman, the CFTC's new Division of Enforcement Director, quote, this action shows that the Commission will not hesitate to bring cases against gatekeepers, including attorneys, who are complicit in violating the CEA, that's the Commodity Exchange Act. Lawyers and accountants have the professional responsibility to avoid participating in an unlawful conduct that is perpetrated by their clients, end of quote. This is a very important case well worth watching. Although the facts of this case may be particularly unique, many will dispute that counsel, whether outside or in-house, are gatekeepers. Insisting that lawyers must avoid participating in unlawful conduct is different than suggesting that they perform any function other than to serve as advocates, confidants, or advisors. Last week, six senior regulators of U.S. agencies appeared before the United States Committee on Banking, Housing, and Urban Affairs to provide their insights on the resiliency of the U.S. financial system since the enactment of Dodd-Frank. The regulators included Mary Jo White, chair of the Securities and Exchange Commission, Timothy Massad, chairman of the Commodity Futures Trading Commission, and Daniel Tarullo, governor from the Board of Governors of the Federal Reserve System, among others. This was Mr. Massad's first public appearance since becoming head of the CFTC, where his presentation was included on the CFTC's website. In his presentation, Mr. Massad mostly discussed the CFTC's agenda going forward. Among other things, he indicated that he anticipates some unspecified, quote-unquote, adjustments and changes being made to previously adopted legislation, but that no, quote, wholesale changes are needed, end of quote. Mr. Massad indicated that, in connection with some proposed rules related to margin for uncleared swaps and position limits, the agency will endeavor to, quote, make sure that commercial businesses like farmers, ranchers, manufacturers, and other companies can continue to use these markets effectively, end of quote. The new CFTC chairman also stressed the need for the CFTC to work with other international regulators, quote, to build a strong global regulatory framework, end of quote, but stressed his appreciation for the challenges of this objective. This is because, according to Mr. Massad, quote, regulation occurs through individual jurisdictions, each informed by its own legal traditions and regulatory philosophies, end of quote. He gave no insight, however, into continuing discussions with European regulators over the recognition of U.S. clearinghouses as so-called qualified CCPs, which is necessary to avoid costs for European banks clearing transactions through them as of December 15th. The Commodity Futures Trading Commission filed and settled an administrative action against Zulu Trade, a Greece-based registered introducing broker, for not following the firm's own anti-money laundering procedures related to screening accounts. According to CFTC, from October 2010 to at least October 2013, this introducing broker maintained procedures requiring it to review potential accounts against a list of targeted countries publicized by the U.S. Department of Treasury's Office of Foreign Asset Control. If a country appeared on this list, Zulu Trade was generally prohibited from doing business with persons and entities from these countries. During the relevant time, the firm apparently relied on third parties to carry out its procedures, as permitted, but failed to have a written agreement with such entities, and Zulu Trade's required screening was not undertaken. As a result, the introducing broker introduced 400 persons from targeted countries, mostly from Iran, Sudan, and Syria. As part of its settlement, Zulu Trade agreed to pay a fine of $150,000 US. The CFTC had charged that the firm's failure to follow its own procedures in screening accounts was a failure adequately to supervise its activities in violation of a CFTC rule. And for those who are counting, that's CFTC Rule 166.3. None of the FCMs to which the relevant counts were introduced were named by the CFTC. And finally, the Commodity Futures Trading Commission's Division of Intermediary Oversight provided exemptive relief to permit certain commodity pool operators that engage in limited commodity interest activities to market their offerings to the public, consistent with new rules that the Securities and Exchange Commission adopted in response to the so-called JOBS Act, or Jumpstart Our Business Startups Act. These CPOs either are exempt from CFTC registration or certain CPO disclosure reporting and record-keeping requirements. CPOs relying on this relief must be engaging in an offering or resale of securities subject to certain SEC exemptions and file a notice with the CFTC. Well, that's it for this week's Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on this website. Until next week, have a great week and ciao!